If you were served with a restraining order and then the other party who asked for protection against you tried to contact you, how can you use that? Can you use it at all? In this video, I'm going to be answering that question and giving you 3 ways to use that information to your advantage when you are in front of the judge. My name is Veronica. I'm a restraining order defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything you need to know to win your restraining order hearing. If that is something that you are interested in, you can get your free first class in the link down below. Okay, so let's jump right in. So you were served with a restraining order, and then the other party contacted you after asking for protection from you, and you're wondering, can I use this in court? How can I show this to the judge? So there are 3 different ways that you can use this. And of course, it depends on what the other person says. First, you can use it to show that the other person isn't really afraid of you. So particularly for domestic violence restraining orders, the other person is saying, I'm so scared. And in fact, usually they will not give you notice of the hearing before. And if they don't give you notice of the hearing, like usually you're just served with the paper, right? And there's a restraining order right there. There's actually a rule that they are supposed to serve you 5 days ahead of time, but usually they will file a piece of paper saying that they could not serve you before the hearing because they were too afraid. So if now they're hitting you up after they got this temporary restraining order in place, maybe kicking you out of your house, not letting you see your kids or your pets, then potentially it can show that that was a lie. They're not really afraid. I mean, if they can contact you after the restraining order is in place, why couldn't they contact you before to give you notice, as they are supposed to do, that there was a restraining order? And lack of notice set aside, restraining orders in the domestic violence context are supposed to be issued to prevent the occurrence of future domestic violence. So if the other party is hitting you up, then they obviously don't believe that there is the possibility of future domestic violence, right? I mean, and of course it depends on what they say, but if they're asking to meet up with you, if they are saying, I love you, I want to get back together, I'm sorry that I filed this thing against you, this shows that they're not afraid. They want to be with you. They want to be in proximity to you. And this isn't 100%, right? This is just one piece of evidence that you can use in your favor at one of these hearings. Second, if they admit that they were lying, then you can potentially use that against them. Now, you cannot respond to them, so that's the tricky thing. Because what you'd probably like to do is try to, if they text you, text them back and say, why did you file false allegations against me? And hopefully they'll say, I know that they were false, everything, I just made it up because I was mad at you, and then you have a great piece of evidence. But you cannot respond to them. So that's really important here. Even if they contact you, it is a violation for you to contact them back. The only way that you can contact them back is through an attorney. So if that is something that happens, they want to dismiss everything, they can just not show up for the hearing and then it will be dismissed, although they can always just refile it again. You can also hire an attorney to negotiate the terms of settlement, and one of those is probably going to be that they can't just go ahead and refile it again next time they get mad at you. Number 3, if they offer to drop the restraining order in exchange for something, then potentially you can use that to show their motive. It depends what it is. If they say, look, if you just agree that I can have full custody and I'll drop this whole thing, well, then that potentially shows their motive. They wanted full custody. Maybe they'll say, if you just pay me a certain amount of money, then I'll drop this whole thing. It can potentially be used for motive. Now, there is a law in California that says that settlement negotiations are not admissible in court. But it really depends what they said, and they may not know that that is a rule, so they may not object to you trying to use this in front of the judge, and the judge may allow you to bring it in. So you might want to try, depending on what they say and how bad it looks for them. Now, again, make sure not to respond. You cannot respond, not through any third party except for an attorney. So be sure that you don't, because that's a violation. And if you violate, that is strong evidence in front of the judge that their DVRO will be granted. I hope you found this video helpful, and look, you can keep binge watching YouTube, hoping to find the answers, but when you're learning something new, you don't know what you don't know, right? So you could watch every single video that I have, or every single video that you can find on YouTube about restraining orders, but what you will be missing is basically a checklist, a syllabus that goes through everything you need to know from A to Z. But you might be missing really big things, and some of those really big things could potentially keep the other side's evidence out, help you poke holes in their responses, help you avoid major errors. And that is exactly what I do in the course. I teach you from start to finish everything that you need to know. So go down to the description box, get your free first class. You literally have nothing to lose. And if you did find the video helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.